Шановні колеги,
Dear colleagues, the Ukraine Crisis Media Center resumes its work, and it's my pleasure to invite here experts from the Political Reform Center who have analyzed the activities of the government in recent past, and they will share their opinion, what was done properly and what was done improperly. Good morning, esteemed colleagues. We have arrived here as a team from our Center for Political Reforms, and we are representing all the spheres covered by our center. We have arrived here today to sum up briefly the outcomes from the first 100 days of the government. We had discussions how to call this briefing. First, we mentioned about first 100 days of the government, but we tried to cover broader sphere of the powers activities, that is to reflect and cover activities of the parliament, of the government, and of the president, because all the branches have to act all together in unity to reach successes and to gain some results. That is, we will try to cover all the spheres of the powers functioning and discuss all the reforms which were launched and carried out. I will start with the constitutional reform and with constitutional and political issues. In line with the coalition agreement, which was drafted by the new parliament and signed by it, it contained well-formulated tasks for the government and the parliament. It truly stated about renovation of the election legislation, and many experts were happy with these prospects, and we expected that the new parliament would actively tackle this issue. Nevertheless, as of today, election legislation is not changed, and only very recently we have observed some discussions started on the renovation of this election legislation. I believe it should primarily tackle the issue of local elections and suggest new draft law on the parliamentary elections. If you look at the last 2 weeks, we may expect that in nearest future these draft laws will be entered to the parliament. The second important issue is constitutional reform. Everybody promised and everybody promised and everybody discussed, and in the coalition agreement it was written down that the constitutional reform will take place. But unfortunately, neither Constitution Commission nor working group were established. The only thing which was done by the President of Ukraine in this area was a very short draft law on so-called repeal of the Member of Parliament immunity. Nevertheless, we believe that this draft law is a controversial thing. We think that deputies' immunity should be limited, but not just cancelled. And while the judges and members of parliament who are compiled together in this draft law, they have nothing their immunities have nothing in common to unite them this way. And moreover, we believe that the issue of judgments immunity is the issue within the scope of the High Council of Judges. And under current conditions, passage of this law might worsen the situation for members of parliament and judges. Also, we continuously hear about intentions of the president to establish the Constitutional Commission. And probably there's quite often discussions recently appeared because of the many claims and charges on behalf of society that constitutional reform is hindered. We have heard recently from Verkhovna Rada Speaker Volodymyr Groysman about intensification of work on decentralization reform, and we expect that thus people in power will manage to improve their images and do something in this area before summer vacations. The third big area is executive branch reform. Many experts, observers, and even members of government brought to attention of the Cabinet of Ministers the necessity to reorganize the procedure and operations within the Cabinet of Ministers. And nevertheless, nothing have been done, and some negative things has been done. For example, liquidation of the state bailies service and the state inspection on state inspection on implementation of court decisions. Unfortunately, this was a negative step which concentrated powers in the hands of one minister, which brings too many things on his discretion. And this is a mistake done in course of Ministry of Justice reorganization. Another negative step was made when changing the procedure for passage of cabinet resolutions and how they are voted by the Cabinet of Ministers. The Cabinet allowed that draft resolutions could be passed without additional expertise of the Ministry of Justice and Ministry of Finance. This emergency procedure, so to say, unfortunately spoils quality of the documents and hampers the cabinet's work. Probably I'll add after my colleagues' interventions. I'm Viktor Tymoshchuk, expert in public administration and judiciary reform. Unfortunately, I have to start from criticism. We urgently needed new legislation on civil service, and appropriate draft law was drafted back in October last year. It had to regulate work of 340,000 civil servants, and unfortunately it stayed idle for all these months, and during the last month it 4 times was withdrawn from the agenda of the parliamentary committee, and thus we come to conclusion that politicians are interested to appoint civil servants based on non-transparent procedures. On the other hand, civil servants are not interested in passage of new law, which will bring in order their work and careers. And another draft law on the administrative procedure, which had to regulate relations between civil servants and people, customers of their services. This draft law also remained idle for 100 years, and nevertheless, we had to pass these laws to implement association agreement. We have already got 200 million euros for this reform, but actually we are doing nothing and hampering our reforms. One small success, this is the regulation law, which has number 1580. It contains several good provisions, which simplifies the licensing registration procedure. It also simplifies some administrative services, but it also has a big shortcoming in terms of paying for administrative services, because it legalizes additional payments for one and the same service, and this is a step back. What to do for future? We would recommend to do one simple thing: to submit to the parliament the laws on the administrative services and on civil service, and to review again payments for administrative services, and to withdraw these payments from the scope of the ministries and transfer them to the responsibility of local authorities. One of the initiatives announced by Mr. Groisman was that payments for local services, local state services, should be collected by local authorities. Good morning, I'm Oleksandr Banchuk. I'm an expert on criminal justice and an expert in the sphere of public administration related to criminal justice. My scope covers reform of the Ministry of Foreign Affairs, justice reform, and also strengthening of criminal responsibility. Speaking about the Ministry of the Interior reform, we should mention in positive context some concrete steps about establishing new patrol service in the city of Kiev. we observe the fourth stage in a competition for hiring patrol inspectors. And by the end of this year, we believe new service with new people and organized in line with new principles will become operational in all cities which have more than 1 million of residents. But nevertheless, patrol service won't act efficiently, won't operate efficiently unless we have new law on police. And the Ministry of the Interior, instead of taking ready draft laws 1189 and 1189/1, these two draft laws were prepared by many experts and discussed with international colleagues. The Ministry of the Interior decided to prepare their own draft law, and immediately they broke this promise, because they promised to enter into the parliament by end of February. This is mid-March already, and as far as I know, only 1/3 of this draft law is ready in the Ministry of Interior, while by midsummer we would like to have this law not just drafted but already passed by the parliament. The second important issue is the prosecutor's office. The problem is that on October 14th, the parliament of previous convocation have passed a new law on the prosecutor's office, which positively was assessed by the Venice Commission. But actually, under the previous Prosecutor General Vitaly Yarema, nothing was done to implement this law. And new team and new leadership of the prosecutor's office, they they are in a shortage of time to get everything ready for the implementation of this law within a month when it comes to force. They promise they will be ready by mid-July this year. They will be able to appoint new people to the prosecutors' offices in the regions, and thus we observe that 4 months of idleness and activity in implementing this law had very negative outcome. What is also important, 8 out of 10 draft laws which have entered the parliament recently, they deal with strengthening criminal responsibility. As an expert, I'm asking myself why we needed to have revolution of dignity, while today we have draft laws about strengthening criminal responsibility for almost everything. And I believe that all things which happened last year, all the events of the last year, they do not provide for strengthening of criminal responsibilities. Our punishments are strong enough against comparison with European countries. Even now, we do not need this strengthening. By summer, we should pass the law on police, we should properly prepare implementation of the law on prosecutor's office and look carefully and prevent these severe amendments to the criminal code. I would like to speak about two top priority reforms as they were distinguished by the president. I'm Roma Kuybida, and I will describe achievements of the new power in the injustice reform. If we compare this sphere against all others, we have bigger successes here. The recently passed laws to implement coalition agreement, they resolve this issue considerably. Nevertheless, the constitutional amendments in this sphere are postponed till 2016. Looking at the Cabinet of Ministers action in the sphere of justice reform, we clearly observe that they stepped back from this very reform and gave priority and leading role to the presidential administration. Upon initiative from the president, the parliament has passed the law on the right to fair justice. Despite that sound name, we should not be deceived. Initiators of this law actually actually recognized and confessed that it's not the reform of justice per se. This is a preparation and gradual transition period for this sphere. It makes a more transparent process for appointment of judges in the high courts. It makes the work of judges more transparent and controlled, and also it allows having proceedings without special permission of the court, and that all opinions of judges should be included to the verdict when it is made in court proceedings. Passage of this law was ignored. Passage of this law has ignored some norms of regulations, and this court reform gains less trust. I believe that this draft law may contain some suspicious provisions, like, for example, some powers and some mandates taken from the previous legislation passed under Yanukovych regime. Unfortunately, in this law, there was an omitted chance which was suggested by Venice Commission. Now we need to wait for the next review of the Venice Commission to use another chance to improve this law. Also, this law has ignored many provisions from the coalition agreement, which was the undertakings taken by members of parliament. In particular, the law does not contain alternative provisions suggested by some members of parliament. As for amendments to constitution, judiciary reform is impossible without changes to constitution, but this law does not provide for such changes, and that's why it does not change the rules of the game considerably. And in the future, it in the future, we will not be able to introduce more radical changes to the constitution, because you cannot change the same provision of the constitution more often than once in a year. That is why, summing up, I can say that the parliament had done some steps which could be assessed as progressive and regressive, but procedural law was not changed, while we need to change procedural law in order to improve the procedure, justice procedure. Looking at implementation of the European standards in judicial reform, we may observe that Ukraine went up from 10th position to 44th. You may find out there's a speedometer of reforms in EU Pravo.org website. And here you may observe the speed of reforms in each sphere. In judiciary reform, it's speeded up in prosecutor's office reform. It also shows some progress, but unfortunately this all is done at the legislative level. We will continue to track down whether those changes will remain positive and whether we will need to interfere to prevent some adversary effects. I am Mykola Havronyuk, expert of the Political Reform Center on Corruption Issues. I am also participant of the reanimation reform package, and corruption issue is the last in today's agenda, but not least. We clearly remember how each party campaigning before elections very strongly supported anti-corruption slogans. It's very interesting to observe the role of all those parties in anti-corruption work in coalition agreement. We actually, as of today, we have two parts of people, two parties of people who in their attitude towards corruption. One of these parties say that will do with the anti-corruption reform. It comprises some people who follow Georgian path in anti-corruption combat, and also some more radical anti-corruption reformers, and the second party, which are supporters of the old corruption path. They want to get more from corruption, and during the last 3 months, we observed passage of some laws, like the law on preventing corruption, the law on the National Anti-Corruption Bureau, and anti-corruption strategy. The laws are good, and this is because they were drafted by civic activists together with experts. Over the last night before passage of these laws, members of parliament have introduced some changes to this law, which unfortunately blocked normal implementation of that laws. And despite the fact that they came to force, members of parliaments applied their favorite way of action, that the laws are passed, but they are inactive, and we would never know whom do the president, the speaker, and the prime minister support, but I never observed any activities on their side aimed at intensifying implementation of this law. I never saw the president come into some commission and requesting them to act more actively to implement this law. Nevertheless, we observe how the head of the National Anti-Corruption Bureau is selected. This has started in late December, when candidates were presented to the committee, and within 3 months we have been observing this TV soap opera, how they are selecting head of the Anti-Corruption Bureau. Now, I do not know how society accepts this when members of parliament from leading parties make changes to the law about selection of this person. Of course, traditionally, we do not have standard political parties. We have parties of the leaders, and here we observe that we are again expecting for a person who will cope this corruption. In the nearest future, we will see who will be elected. When President wanted to make an appointment to the ministry positions, they managed to pass all necessary tests within 1 day and got Ukrainian citizenship within 1 day. Sorry, we will have not enough time for questions and answers. And the last step which we had to do was establishing National Committee on Preventing Corruption. Unfortunately, no specific concrete steps were done in this direction. That is, we are beyond our time frame, and instead of this, we are doing something strange. And now I would like to sum up. As you have seen from all our presentations, we actually do not see that government is doing some harm, but the things are going very slowly. And today we are like running up the escalator which is going down, and we have to move much more faster than the escalator moves down. Unfortunately, our authorities do not demonstrate this ability to run up faster than the escalator is going down. Sometimes people say how to do things, in a way doing nothing. Now your questions.
I have several questions. I would like you, Mr. Koliushko or Mr. Viktor, to dwell upon in more detail about the draft law on state service, regulating the activities of more than 1,400 public servants. If we lack this law, will this mean that new people at ministerial positions will change nothing? And will this commission start operating this very year? I would like to start telling you that it has nothing to do with ministerial positions, because ministers are political positions. And here we see, so to say, a tendency, a threatening tendency on one side, or to tell it different, in order to reform the power, we have to solve three issues. We have to change the procedure of its internal organization, who does what, to change the procedure of coming to the state authorities and solve the issue who may not be a candidate to the state position. Currently, we have solved only the third issue. We have the law on lustration, which is somehow active, but the remaining two issues are not solved. The law on lustration is so far negative, because it just clears the positions, and the politicians, according to the old procedures, invite whoever they want to invite. So we see invitation of people to the positions through the patronage service, and we have to do another revolution, to organize another revolution to clear it up, to change the situation. Do we have other questions? If we have no questions, I hope that we celebrate 100 years, maybe half a year. So I hope that in half a year we have positive changes. Thank you very much. In several minutes. I beg your pardon, we have one question. Mykola Mykola, the Independent Center and a member of Journalists Association. I know your good work and your goodwill to improve the legislative system, but so far I would like to ask you, don't you believe that there is no control over the state power? And if it's not control, people may not have any influence on such power. Tell us, please. Previously, if you remember, there was a committee of people's control, and without any expenditures, people were controlling the violations. I may give you the materials to renew the people's control in Ukraine. If to speak about people's control, there are plenty of discussions. And I remember that nearly a year ago, after victory of the Dignity Revolution, I was invited to this or to that tent or to some construction at Maidan to bespeak creation of different structures of national control, of people's control. And there are plenty of myths, because people believe if we are registered as an NGO and call ourselves people control, and that includes to our mandate that nothing can be done without our permission. It will settle, resolve serious problems. Now it will change nothing, because if the situation is like this very people's control organization would be the real power in our country. That is why, frankly speaking, while forming or while developing the state power and ensuring its transparency, we shall not do these substitutions. We shall not strive to create something to control the power, because who will be controlling us? We have to ensure transparency and clear procedure of decision making. If the state power decides, drawn up everything clearly, then this will be the predisposition for people to influence the state power and understand what is done by the state power, and it will improve the quality of decisions. We have appropriate proposals in the package of laws we are be speaking here. Thank you so much. See you.